Welcome back to the High Court Report. We come to you this Monday, November 24th, just a few short days from Thanksgiving. Today, I'll play a mashup of oral argument highlights from the October cases. I curated some of the most insightful moments from these cases. I really enjoyed listening to the arguments. Each time I listen, I pick up something new. We also got to hear some exceptional orator skills. Arguing before the Supreme Court requires an incredible skill set, all of which must be harnessed on the fly. Putting aside the immense knowledge you must have at the ready, successful advocacy requires listening, persuasion, brevity, organizing answers, conceding and quickly pivoting, detecting trick questions, speaking to the 9 justices, and more. Before we dive in, let's walk through a couple of housekeeping matters. First, I want to share some exciting news. We're officially on YouTube. Go to www.youtube.com/@the-high-court-report. Right now, our YouTube page links to our podcast episodes. I'm still organizing the content, and it's a work in progress, but I do hope in the future to add video, so stay tuned. We're also on LinkedIn. Just search the High Court Report. I would love for you all to follow me on these pages, to reach out to me, and to share this content with family and friends. Second, a week ago, during the Trump v. Slaughter case previews, I briefly walked us through the Supreme Court calendar for December. Check out that episode for more details. In addition, check out last week's case preview episodes and this upcoming Friday's episode for a rundown of the cases. I want you all to feel armed and ready for the December term. In last Monday's episode, we also roadmapped our episode list for the next 2 weeks. My goal is to load you all up with content that can carry you through the holiday break. Now that our December episode previews concluded, this week I offer something lighter. Tomorrow I'll release 2 episodes. One includes highlights from the November cases, and the second includes highlights just from the Trump tariff cases. I must admit, I had trouble excising clips to make these mashups. To me, I like to hear the back and forth. Sometimes one question and answer don't capture the dynamic in the moment. Sometimes it takes a few questions for the justices and the advocates to make their points. That's why the episodes ran long today and tomorrow, but I included chapters for each of you so you can quickly skip forward and backward if any particular case interests you. On Wednesday, I'll peel back the curtain and talk about why I created the podcast. You'll get to learn a little more about me on Wednesday's episode and on Friday's episode. On Thursday, we're off for Thanksgiving. And on Friday, Black Friday, November 28th, we'll have our first ever High Court Report mailbag episode. No question or comment is off limits. I'll answer anything from Supreme Court cases to my favorite movies to my hobbies. I know I set a deadline of Monday, November 24th, but we'll extend that deadline to Tuesday, November 25th. Send your comments and questions by email to scotus.cases.pod@gmail.com or message us on LinkedIn at the High Court Report. We'll also recanvass the December Supreme Court calendar. I'm intrigued by quite a few of these cases. All right, that's it for housekeeping. Let's move on to the feature of today's episode, October Oral Argument Highlights. I hope you enjoy. Let's dive in.
And let me ask you this. If you had to concisely say, as Justice Sotomayor said, you identify a number of different rules that you think preclude application of this Delaware rule in federal court. Let's put aside the Rule 11. Let's say I'm not persuaded by that. Concisely say to me, if we were going to write this opinion and we were going to say that under Hanna versus Plumer, there's a direct conflict here and so the federal rule has to apply, concisely say what you think the best rules to point to were. What would the reasoning be?
So Rules 8 and 9 set forth what a plaintiff must do to state a claim in federal court. And Delaware's law adds an additional evidentiary requirement that you have to.
But 8 says just pleadings, and an affidavit's not a pleading. So tell me why Rule 8 precludes this.
So, Mr. Yerger, suppose a state said, this notice pleading stuff, we're really a little bit tired of it, and we want to go back to code pleading. And so we're going to enact a requirement, and it says, it's going to say for some category of suits, or for all suits, who knows, you have to do code pleading. We're not going to insist you do it in a complaint. You can just do it in a separate document. Call it an affidavit of merit. Call it a non-pleading if you want to, but it's got to be filed very early in the lawsuit. Would that be all right?
If it's an affidavit that's separate from the pleadings,
that's what we're calling it. We're calling it an affidavit of merit.
Of course, my position is you can enforce that. I think the question is...
So you can enforce that. I mean, that is it's like exactly what Rule 8 and indeed the entire structure of the federal rules was designed to prevent. If that were right, if you're just relying on Rule 3, Delaware goes and changes its statute and says you have to file it 20 days later, right? Then you don't have Rule 3 anymore.
That is true. That is the narrowness of it is that you would only be addressing.
Yeah, I mean, the fundamental thing, isn't it, is the entire thrust of the federal rules, most particularly in Rule 8 and 9, which is it was meant to establish a notice pleading system where all you had to do was to say, here I am, here's my claim, I'm going to be seeking damages, the end, and everything else was supposed to happen later in the normal course of things. And then a defendant had a bunch of different opportunities, starting with Rule 12 and then continuing on with Rule 56 summary judgment, or using summary judgment even pre-discovery in various circumstances to get rid of the suit. And that's basically the structure of the federal rules.
Yes.
Right?
The affidavit is a public document?
No, the complaint in federal court
yes,
is
correct.
a public document, and that's all that's required to get the case up and running, and a defendant has to respond, right? So there's a delta there, and you are cracking and extracting, as your friend on the other side likes to say, some things from the Delaware rule that you would apply in federal court and other things that you wouldn't. Isn't that fair?
Well, I think that is true of many state statutes and substantive rules laid out in state court decisions. It's never been true of Erie that in order to apply state law in federal court, you have to take every single sentence written by a state Supreme Court and apply that in federal
court. Well, how do we know what the Delaware state legislature would do? I mean, we're creating this Frankenstein of a statute, right? We're taking bits and pieces and adapting it. And I understand your point, but what authority does a federal court have to rewrite Delaware law in that fashion?
My point is that this is a totally different procedure, correct, than what the federal rules set forth?
It is a totally different procedure. It is a procedure created by the statute to facilitate the procedure created by the statute.
Can I talk to you about, I know you have a bunch of different rules that you say this violates 3, 8, 9, 11, 12. But the essence of all those rules is that the federal rules require a concise and precise statement of your claim.
Yes, Your Honor.
And that it has to be legally sufficient, correct?
Yes, Your Honor.
The affidavit rule, instead, is talking not about legal sufficiency, it's talking about factual sufficiency, correct?
So that is respondent's position, and I'm happy to embrace it because I think
they're right. It's factual sufficiency, but that's not the purpose of the federal rules, is it?
No, not at this stage of
not at the pleading stage.
Yes, Your Honor.
All right. Why couldn't they have just made either a motion to dismiss and asked for it to be converted into a motion for summary judgment if an affidavit wasn't provided? They had.
Yeah, yes, Your Honor.
My point is that this is a totally different procedure, correct, than what the federal rules set forth.
It is a totally different procedure. It is a procedure created by the statute to facilitate the procedure created by the statute.
Can I talk to you about? I know you have a bunch of different rules that you say this violates 3, 8, 9, 11, I don't know, 12. But the essence of all those rules is that the federal rules require a concise and precise statement of your claim.
Yes, Your Honor.
And that it has to be legally sufficient, correct?
Yes, Your Honor.
The affidavit rule, instead, is talking not about legal sufficiency, it's talking about factual sufficiency, correct?
So that is respondent's position, and I'm happy to embrace it because I think
They're right, it's factual sufficiency, but that's not the purpose of the federal rules, is it?
no, not at this stage of
Not at the
litigation.
pleading stage.
Yes, Your Honor.
All right.
And let me ask you this. If you had to concisely say, as Justice Sotomayor said, you identify a number of different rules that you think preclude application of this Delaware rule in federal court. Let's put aside the Rule 11. Let's say I'm not persuaded by that. Concisely say to me, if we were going to write this opinion and we were going to say that under Hanna versus Plumer, there's a direct conflict here and so the federal rule has to apply, concisely say what you think the best rules to point to were. What would the reasoning be?
So Rules 8 and 9 set forth what a plaintiff must do to state a claim in federal court. And Delaware's law adds an additional evidentiary requirement that you have to
But 8 says just pleadings, and an affidavit's not a pleading. So tell me why Rule 8 precludes this.
So Rule 8 precludes this because Rule 8 implicitly forecloses the application, the requirement that you come to court with a bunch of evidence, just as it would preclude coming to court with new particularity requirements or other requirements that you would have to put into the complaint.
So, Mr. Yerger, suppose a state said, this notice pleading stuff, we're really a little bit tired of it, and we want to go back to code pleading. And so we're going to enact a requirement, and it says, it's going to say for some category of suits or for all suits, who knows, you have to do code pleading. We're not going to insist you do it in a complaint. You can just do it in a separate document. Call it an affidavit of merit. Call it a non-pleading if you want to, but it's got to be filed very early in the lawsuit. Would that be all right?
If it's an affidavit that's separate from the pleadings,
that's what we're calling it. We're calling it an affidavit of merit.
Of course, my position is you can enforce that. I think the question
so
is...
you can enforce that. I mean, that is like exactly what Rule 8 and indeed the entire structure of the federal rules was designed to prevent. If there was one thing that the federal rules did, it was to say notice pleading uniformly throughout the nation in federal courts.
And this is not a rule of pleading, which is our point. The pleadings itself.
But the hypothetical I'm giving you is all we do is call it something different, and we're back to a code pleading system. If that were right, if you're just relying on Rule 3, Delaware goes and changes its statute and says you have to file it 20 days later, right? Then you don't have Rule 3 anymore.
That is true. That is the narrowness of it is that you would only be addressing.
Yeah, I mean, the fundamental thing, isn't it, is the entire thrust of the federal rules, most particularly in Rule 8 and 9, which is it was meant to establish a notice pleading system where all you had to do was to say, here I am, here's my claim, I'm going to be seeking damages the end, and everything else was supposed to happen later in the normal course of things. And then a defendant had a bunch of different opportunities, starting with Rule 12 and then continuing on with Rule 56 summary judgment, or using summary judgment even pre-discovery in various circumstances to get rid of the suit. And that's basically the structure of the federal rules.
Yes, and I think that puts the finger right on why we put so much weight on 8 and 9.
Mr. Tutt, what you say is compelling in a lot of ways, but your friend on the other side is going to say Gasparini, and that there the court did this crack and extract thing and took what they could of it and ditched what they couldn't. What do we do about Gasparini from your point of view?
Well, so the court determined in Gasparini, the court majority determined that there was no direct conflict with Rule 59. That Rule 59 provided a mechanism for the enforcement of the substantive New York standard for reviewing excessive jury verdicts.
Right. How would you have us distinguish it is my question.
So we are a direct conflict case. So we are a Shady Grove case where, because a federal rule unavoidably conflicts, you don't get to the murky waters of Erie, which was
So
what
you
happened
think
then.
Shady Grove properly understood, and I think you're embracing even Justice Scalia's opinion that's not for the full court, says once we're in federal rules of civil procedure land, we're not going to play with Hanna, we're not going to play with Gasparini. Is that a fair summary of your position?
Can you just help me to understand why, and this is kind of particular. You say the case has to be dismissed if the affidavit isn't filed, but when I look at the actual language of the statute, it says the clerk of the court shall refuse to file the complaint and it should not be docketed with the court. That is actually technically a different dynamic than having accepted it and it being dismissed. And so what I don't understand is why we don't just have a plain conflict with Rule 3, which is the rule that tells us in federal court when a case is commenced, when you file it, when it's docketed.
Sure.
This says the clerk has to refuse to docket the case, not that the judge has to dismiss it. And I think that's a relevant distinction. Am I wrong about that?
I don't think it's irrelevant, but first let me say the statute also doesn't tell you what to do if more time is given and the plaintiff never actually produces the affidavit. Case law does. It's very clear under Delaware law that the case has to be dismissed.
Just ask you about one of them, because getting back to Justice Barrett's question, I thought your sort of clearest, most narrow, direct conflict was with Rule 3. And I know that you mention it, but you really rely on 8 and 9 in ways that I don't know are necessary. I thought the theory was that we have this Delaware law saying what is necessary to file or initiate a malpractice lawsuit as a matter of procedure. You have to have this separate AOM. Notably, it's not evidence. It is just what is a necessary step to initiate this lawsuit. And under federal law, no such thing is required. The federal law says that the action commences by filing a complaint with the court. So why isn't that just clear, narrow, direct? It doesn't rely on any thoughts about factual versus legal.
Can I just turn real quick to your Rule 11 response, because your friend on the other side makes a big deal out of it. And you say, well, it's distinguishable because it only speaks to federal statutes. And he's going to get up here, and I know he's going to say, well, look at the original federal rules of civil procedure. They expressly distinguish between federal statutes and statutes simpliciter. And therefore, when we see statute simpliciter, as we do in Rule 11a, we should encompass states. You know the argument. Okay. And assuming there's some force to that, do you have some other argument? For example, could one say that 11a has to do with pleadings and verifying the pleading? Either the attorney or the plaintiff, defendant, whatever, has to verify the pleading. And an AOM ain't any of those things.
Absolutely, Your Honor. We could have developed this argument more in our reply brief if we had more words.
I wondered, yeah.
But there is a contemplation that, an affidavit and a verification have an understood meaning in federal court. And
with respect to pleadings, which that word is in the rule.
Yes, Your Honor.
And is an AOM a pleading?
Yes, and an AOM,
it's not by one of the parties. I mean, it's a third party document.
So the most basic one that's always been known is attorney fee shifting. So if you bring a frivolous case, you're going to pay, or just a bad case even, you're going to pay your opponent's costs and their attorneys. That would be a powerful weapon against malpractice plaintiffs that are seeking strike suits. Obviously, states have enacted shorter statutes of limitations for these types of claims to make sure that if you suffer malpractice, you come to court quickly to assert it. They put caps on damages. They increased the burden that a plaintiff must carry to actually win one of these cases. So, for instance, you actually must prove your case in most cases through expert testimony. So at some point, a doctor is going to have to come in and actually say there was medical malpractice. You can't just come into court and say, I was really hurt. Jury, give me money because this doctor is, a wealthy doctor.
Well, is your argument reduced to the proposition that there is no such thing as a cause of action for medical malpractice in Delaware? What there is a cause of action for medical malpractice that is confirmed by an independent affidavit of another practitioner.
So I don't think that that's what Delaware has. I think that the clearest evidence is that this statute doesn't just apply to Delaware causes of action. So if you came into Delaware court and you were bringing a medical malpractice suit under Florida law, it would have to still apply. And I'll tell you why. The prothonotary is not to docket the complaint in Delaware court unless it has an affidavit of merit. But the prothonotary is not an expert in choice of law analysis, and so is going to just have to look at the face of the complaint to determine whether or not it's a medical malpractice claim that requires the affidavit.
Mr. Clement, how do we know that petitioner will suffer a risk of competitive harm?
So in some respects, we know that from the very fact that he is a candidate in the election. I mean, obviously, he's put that in a declaration as well, but I think this is something where every candidate cares very deeply and uniquely about the outcome of the election, but also their vote tally and the margin of victory or the margin of defeat. And this idea that, all a candidate can care about is the ultimate win-or-loss, I just don't think that maps on to the way elections actually operate or people think about them. If you ask candidates, would you like to win this election by 60% of the vote or 51% of the vote, I think 100% of the candidates are going to say, I'll take the 60%.
Yeah, but that's not how we ordinarily think about harm. And harm is what you need in order to establish standing, not preference for 60% or 59% or whatever. And so what I guess I'm a little concerned about in your argument is the idea that a candidate who wins and who wins by some margin is harmed by a regulation of this nature because of the potential decrease in his margin of victory. I don't understand the harm that necessarily comes from that.
So if you start with the premise that every candidate would prefer to win 60% rather than 51%, and then you challenge...
Why do we start with preference? That's what I'm saying, that the relevant metric for standing is harm. So, yes, fine, you might be disappointed, but that's usually not what we look at when we're determining whether or not someone is actually harmed.
Well, I would say that if a law improperly denies somebody their preference, that is a harm. But in all events, I don't think you need to make it that abstract. If the abstraction is what's bothering you, he alleges in his declaration that that is accompanied by reputational and financial harms as well.
Isn't that speculative? I mean, couldn't we also speculate that a candidate who decreases the margin of error, or the margin of victory, who wins by a smaller amount, people would actually want to contribute more the next time, as opposed to them not having contributors? I don't necessarily see a financial harm that comes from a smaller margin of victory.
Well, on this, I think this is the kind of issue that at this stage of the case, where you have a complaint and you have declaration, you haven't had any evidence. If the other side wants to come in and put on an expert that says, actually, Congressman Bost, who's run successfully in Illinois like a dozen times, doesn't know what he's talking about.
No, I'm saying it's your burden. You're the petitioner, and you have to establish standing. You're the plaintiff. So you have to show that you have a non-speculative risk of harm here. And I just don't understand how saying, well, I would prefer to win by more actually counts, especially when you're winning by, more or less is sort of speculative in this context.
Well, with respect, I think if you're going to allow people to challenge election rules at the beginning of the election, which I actually think is something that the standing doctrine should not get in the way of, because it avoids having these disputes litigated at the worst possible times, you're going to have to allow some room for a little bit of speculation. I mean, because the election hasn't happened yet. But the way that this Court's cases have generally dealt with that is you have to show that there's a substantial risk of something. And here, there's no question in my mind that at this stage of the litigation, between the allegations and the declarations, he's done enough for the motion to dismiss stage. Again, we all know that standing law has to be sort of addressed at the level of substantiality for every stage of the litigation. And so if they want to continue to contest this, I suppose at the summary judgment stage, we could have competing experts on some of this stuff. But frankly, I think that is a pretty good advertisement for a broader, simpler rule that simply says candidates have standing to challenge the rules that govern the election.
I mean, your rule really does just take out the injury requirement entirely. It just says you should assume that if a candidate is there before the court, the candidate has good reasons for being there before the court. And for the most part, I think we have rejected that view of standing. I mean, for example, we said there's no such thing as doctor standing just a couple of years ago. So, too, here, it seems quite inconsistent with our standing law to say, oh, we just have like an automatic rule for candidate standing. On the other hand, I'm sort of in sympathy with the view that this bar should not be all that high, and that the bar shouldn't have to, you shouldn't have to say, here are the polls that show I could lose as a result of this rule. It's like all you have to do is come in and say why it is that the rule puts you at a disadvantage relative to what's come before.
So, Justice Kagan, I don't think that much separates us. And so I don't want to sort of die on any particular hill here. The reason that I'm hedging a little bit, I'll say two things in response. One is I don't think we're saying get rid of the the injury in fact requirement. We're just saying unlawful ballots being counted in your election is an injury in fact. It's a little abstract, sure, but it is an injury in fact. And then everything else follows, and then you don't even have to get into what I still think is an uncomfortable prospect of competing expert affidavits where one party says that actually late-breaking votes can actually be good for Congressman Bost because people like candidates with a B in their name or something, and then the other side says, no, they're actually good for the Republicans.
Mr. Clemento, if you could just answer whether you could satisfy Justice Kagan's standard, I'd be grateful. And it doesn't require a competitive, as I understand the question, it doesn't require a competitive disadvantage. It just says compared to the law, what I understand the law to have been, I am at a disadvantage.
Yes, we can satisfy that.
Can you spin that out?
Sure. I mean, we can satisfy it in sort of two ways. I mean, one, Congressman Bost in his declaration has made clear that he thinks that this rule will hurt his margin for victory. And then the second thing he said, and maybe said this frankly more clearly, is because we have kind of the unique benefit here of a candidate who was a candidate under the old rules. And he has said that this change in the rules has increased the cost of running his campaign.
I mean, your rule really does just take out the injury requirement entirely. It just says you should assume that if a candidate is there before the court, the candidate has good reasons for being there before the court. And for the most part, I think we have rejected that view of standing. I mean, for example, we said there's no such thing as doctor standing just a couple of years ago. So, too, here, it seems quite inconsistent with our standing law to say, oh, we just have like an automatic rule for candidate standing. On the other hand, I'm sort of in sympathy with the view that this bar should not be all that high, and that the bar shouldn't have to, you shouldn't have to say, here are the polls that show I could lose as a result of this rule. It's like all you have to do is come in and say why it is that the rule puts you at a disadvantage relative to what's come before.
So, Justice Kagan, I don't think that much separates us. And so I don't want to sort of die on any particular hill here. The reason that I'm hedging a little bit, I'll say two things in response. One is I don't think we're saying get rid of the the injury in fact requirement. We're just saying unlawful ballots being counted in your election is an injury in fact. It's a little abstract, sure, but it is an injury in fact. And then everything else follows, and then you don't even have to get into what I still think is an uncomfortable prospect of competing expert affidavits where one party says that actually late-breaking votes can actually be good for Congressman Bost because people like candidates with a B in their name or something, and then the other side says, no, they're actually good for the Republicans.
Mr. Clemento, if you could just answer whether you could satisfy Justice Kagan's standard, I'd be grateful. And it doesn't require a competitive, as I understand the question, it doesn't require a competitive disadvantage. It just says compared to the law, what I understand the law to have been, I am at a disadvantage.
Yes, we can satisfy that.
Can you spin that out?
Sure. I mean, we can satisfy it in sort of two ways. I mean, one, Congressman Bost in his declaration has made clear that he thinks that this rule will hurt his margin for victory. And then the second thing he said, and he's maybe said this frankly more clearly, is because we have kind of the unique benefit here of a candidate who was a candidate under the old rules. And he has said that this change in the rules has increased the cost of running his campaign. Yeah. So on both those two kind of classic injuries, I think the declarations here are sufficient. Obviously, we're just at the motion to dismiss stage, so
Thank you.
There could be more, but I think they are satisfied.
Mr. Clement, when you say that these two classic injuries, how, if at all, does TransUnion affect this? Do you have to show that there's some sort of history and tradition, that this is the kind of injury, either the vote margin or the risk of electoral loss, that counts as a cognizable injury?
So two thoughts on that. I mean, one, if we have to, then I think the pocketbook injury just makes it easy because that's classic, go back, Blackacre, whatever. That's like the classic old school injury. The second thing I would say, though, is I do think there's some artificiality in some of these contexts to force everything to be run through the pocketbook injury. I mean, Congressman Bost is injured in the pocketbook, but that's because he's a candidate in an election with a ballot with his name on it. And I think if you go back to the relevant history here, I don't know if 133 years counts, but I'd take you back to McPherson v. Blacker. And that was a case brought by presidential electors challenging Michigan's change of the rules for the presidential electors. Michigan went from statewide to a district-by-district way of having presidential electors. This court thought a lot about justiciability in that opinion, didn't bat an eye about standing. Of course, the presidential electors are the right people to challenge a change in the rules for presidential electors. And then I would also take the court back, not ancient history, but Crawford against Indiana in the voter ID case. There was a question about the standing of the Indiana Democratic Party. Justice Stevens, in footnote 7, dispatches it in two sentences. Of course, the Indiana Democratic Party has standing to challenge a voter ID law that they think is going to be bad for Democratic candidates. And Justice Souter agreed with that, so there's at least 5 votes for the proposition. And his footnote was just as short. It's just common sense that in these contexts, the candidates, who are the ones, as Judge Oldham said in his opinion, they take time off from the elections, their names are on the ballot.
Thank you, counsel. You've answered a lot of hypotheticals. I just want to make sure I understand what your opening submission is. It is, hi, I'm a candidate, these rules apply to me, and I'm suing, right?
And if that's not enough for you...
No, but that is the opening pitch, right? That he's the one that's affected by the... Well, that's the question, I guess. Whether is it enough to simply say, hi, I'm the candidate and I'm suing?
So I want you to believe that it is. If it's not enough, I have my 2 fallback arguments. But I think the reason it is enough is because in every one of these cases, I mean, you can run it one step further, which is what I tried to do with Justice Kagan, and you can say it's not just that I'm a candidate. I'm a candidate here, and I have an injury in fact, which is I think there are going to be unlawful ballots counted in my campaign.
So you make a lot of practical arguments that I think have force. What do you think, what effect, if any, do you think that adopting your theory would have in other areas of standing law? Because we've been pretty careful about procedural injury. You know, an excellent lawyer who argued TransUnion convinced us to do that. What do you think this – you're asking for something, as Justice Kagan points out. We don't fashion bespoke rules for standing in particular contexts. So what spillover effects would we be worried about in writing an opinion in your favor if you win?
So I don't think we're asking for a bespoke rule. I think, obviously the parties fight about this in the brief, but I think what we're asking for is the application of the ordinary standing rules that would be second nature in the context of a regulated industry to just apply in the electoral context in the same way.
I'm sorry, look, what you're sketching out for us is a potential disaster. In other words, you're saying if the candidate's going to win by 65%, no standing. But if the candidate, hopes to win by a dozen votes, and there are places in the country where that happens over and over again, then he has standing. But we're not going to know that until we get very close to the election, right? And so it's going to be in the middle, the most fraught time for the court to get involved in electoral politics. That's when you say we should jump in, as opposed to the more general, broad rule. Mr. Clement's broadest rule, I guess, is, look, he's a candidate. He's challenging a rule in the election. Isn't that enough? And one reason, as I say, we'll be deciding that case then, 6 months, 9 months, maybe 2 years before the election, as opposed to the day after the votes have been counted.
So I don't think that is an accurate description of our position for a couple of reasons. I don't think that there is a concern that standing will only be available right before an election and only in close cases. And that's for two reasons. The first is that the evidence that a candidate plaintiff could use to show standing isn't simply sort of limited to polling data. I think Meese versus Keene is very helpful on this point. In Meese versus Keene, the court described two types of information that the candidate used to establish standing. One was polling data. One was, the expertise of a political advisor. But I don't even think that those things are necessary in a case like this one, where we are dealing with a very experienced and successful candidate. Congressman Bost has been successfully running for election for 30 years. At the time,
when you run for election for 30 years and win, sometimes you get you act as if you have no risk of losing, and you know what happens then? You lose. A candidate who acts as if there's no risk of losing often loses. I don't know. And then you'd say rely on polling data. Are polls always reliable? What would a clear statement, what more would Congress have to do, do you think?
Well, we have a clear statement in E itself with respect to state prisoners, with respect to habeas applications. What we don't have is a clear statement in H, where we're talking about federal prisoners. And we pointed this out in our initial brief with the Hone decision. And that case drew a contrast between B3E as a clear statement and the certificate of appealability provision in 2253, which didn't have that. And we think that same sort of contrast exists here with B3E and 2255H, which says nothing about jurisdiction.
2255H does say, and this is just as I'm trying to think about this argument, this clear statement point that you have, I think, is your best one on your broader argument. 2255H does say, though, that a second or successive motion must be certified as provided in Section 2244 by a panel of the appropriate court of appeals. So what are we to make of that? It says certification has to come from a panel, and then one could flip back to 2244 and say that this whole section in 3 is talking about how that certification happens by a panel, and then E says, and it really happens by a panel. The panel's word is final.
Your Honor, I understand that point. That's not what E says, however. All E does is prohibit a petition for rehearing, so that's why every circuit to look at this has said that sua sponte rehearing is still on the table. All we're saying is that B3A through D say that the certification determination has to be made by a 3-judge panel, but it doesn't prohibit rehearing petitions by federal prisoners. So it's a difficult argument and a difficult issue, again, that I don't think the court would have to address if it went with one of our narrower arguments.
I mean, what E tells you is when this certification process generally stops. I suppose that's the same point that Justice Barrett is making, and it seems to be slicing the bologna pretty thin to say, well, we'll do A through D, but then we won't do E, even though E basically puts the period on what A through D says. It says, here's when it ends, the certification process.
Sure, Your Honor, we take that point. I think the key word that you just used is process, which is not a word that's used in H. That's a word that's added by the government in its brief, along with the words final and conclusive.
I take the point, but it's what H is about is how something gets certified. So it doesn't seem to be too much of a leap to say when you're talking about how something gets certified, you're talking about the certification process, and that includes sort of the statement which E gives about when and how that certification process ends.
Sure, Your Honor. So again, our argument is based on the full text of H, certified as provided by a panel of the appropriate court of appeals. We think that only covers the provisions that provide for certification. E comes after that determination has been made.
Could you win without the clear statement rule?
I'm sorry?
Could you win this argument without the clear statement rule?
I think so, Your Honor. But again, I think we're perhaps losing sight of the bigger picture here, which is that the top priority in this case, we think, is for this court to be able to resolve the circuit conflict on B1. So we don't have a particular dog in the fight on how the court resolves its own jurisdiction here. And that's why I keep coming back to our narrower arguments, because to the extent that anyone is concerned about the implications for this, the narrower arguments would avoid that.
Do we normally use probable cause standard outside of the criminal context?
Your Honor, the court has applied probable cause in camera, for example, with respect to administrative warrants, and in other contexts as well. I would point to, for example, Wren, where the court applied it to civil vehicle infractions. And so the court has applied it in non-criminal contexts.
What is the objectively reasonable basis standard?
Your Honor, I think the objectively reasonable basis standard applied in Brigham City calls for and really contemplates, sort of lends itself to some standard of certainty. And our position is that that standard of certainty is probable cause, the traditional standard that the court has applied. Yes, Your Honor.
Well, I mean, I'm just asking what it means. Is there any difference between that and probable cause?
Your Honor, we think that the standard sounds in probable cause. The court didn't use those words in Brigham City, and it did not use those words in Fisher. But we do think that the standard echoes probable cause. I'd point, for example, to the language in Pringle, where the court said that the substance of all probable cause definitions is reasonable belief of guilt. And so while the court didn't use the word probable cause, we do think that there is an echo between the standard applied in Brigham City and the probable cause standard.
Well, I was just going to say, when we talk about probable cause, we use it as a shorthand. It's probable cause of what?
So, Mr. Chief Justice, here it would be probable cause that an occupant is seriously injured or imminently threatened with such injury. Ordinarily, it would be probable cause to think a crime is being committed. But here, as the government explained in its brief in Brigham City, the object might change. But the way that the standard applies and the level of certainty does not.
Why isn't it something like probable concern or reasonable concern? It seems to me that you're taking a totally different context and applying these things just because we're familiar with them and because authorities are involved. I mean, did they enter this home because they were concerned that, I forget the name of the individual, would harm himself? Or was it because they wanted to arrest him for a particular criminal activity?
So, Your Honor, the dispatch call was for a wellness check. But I think to get to your original question, the court has applied that probable cause standard even though the object of it might change in different contexts. For example, Wren, a civil vehicle infraction, that's not a crime, and the standard's still mapped onto it. And we think that it maps on to the emergency context quite well, because officers and first responders don't have complete information. They're just trying to assess whether there's an urgent emergency that is happening behind the front door, and probable cause would help them do that.
You'd say urgent emergency. I mean, let's just say it's a patrol or whatever, he looks in the window and there's somebody who seems to be in some distress. Now, is he supposed to say, I can't tell if, he has a pain is, or if he's having a heart attack or whatever before, entering?
Mr. Chief Justice,
or even just lying on the ground. Why is that person lying on the ground?
Well, the court said in Fisher that you don't have to have ironclad proof that somebody is dying before you go in. But the standard is, under the emergency aid exception as defined in Brigham City, seriously injured or imminently at risk of such injury. And so I do think the court has fixed the threshold, but it said you don't have to have ironclad proof, and that's consistent with probable cause because, of course, probable cause also does not require ironclad proof. What it requires is a fair probability or a substantial chance, And we think that that strikes the right balance given the important and really fundamental interest in the sanctity of the home.
Your argument very odd, right? We're trying to think about a standard here, and I would think that the relevant criteria are the amount of information that the officers had.
Yes.
And the threat to the individual, the actual nature of the emergency. And so in this very situation, I'm thinking the fact that they had a lot of information about Mr. Case actually hurts your cause, not helps you. I mean, I understand you want them to draw a different inference about it, but, this person had a long history of threatening suicide, whether it be by cop or whether it be on his own or whatever. We have a long conversation, detailed, specific, with the girlfriend about circumstances that look like they're creating a pretty significant emergency. I would think this, kind of like what Justice Alito was suggesting, on our axis of information and threat or risk, this seems like it's pretty high.
Justice Jackson, I think that information led the officers on the scene, because there are deliberations that are captured on body cam. Those deliberations by officers with quite a lot of extensive experience with Mr. Case are powerful evidence that Mr. Case was unlikely to shoot himself, because they're talking about him provoking a confrontation with the police. And I would just quote, for example, Police Chief Sather says, "He ain't got the guts. This is probably the 10th time I've dealt with him doing this." Or Sergeant Pasha, who says he's been suicidal.
I wonder if this is just a labeling exercise, Mr. Rowley, at the end of the day, because when we're interpreting the Fourth Amendment, we often look at what the common law has been, what positive law. We don't always, but we often do. Katz is another thing, but Jardines tells us to look at the actual law. And one thing I'm struck by here is, a private person would have a good necessity defense to a trespass claim, always, historically it appears, from what I can tell, when it reasonably appears necessary to prevent serious harm to the occupant. And that's almost exactly what Brigham City says for officers. And officers can't have any fewer rights than a private citizen to enter a home to render assistance. Now, that doesn't give them a license to go rummage about the place for crimes, but it does give them a license to enter to render assistance, I would have thought. What's wrong with just saying Brigham City reflects traditional common law principles and officers treated the same as private citizens?
Justice Gorsuch, I have a few responses to that.
I bet you do.
I think the first response is, when the court looks to common law examples, what it's asking about is what the authority of constables was at common law. And so I just point to Wilson, for example. The common law of search and seizure recognized the law enforcement officer's authority to break open the doors of a dwelling. So it's what was the constable's authority at common law?
But it doesn't. The constable doesn't have fewer rights than a private citizen.
We've
often said that.
Justice Gorsuch, when the court talks about that, about the ability of officers to do the same things that an ordinary person is doing, ordinarily it's talking about whether there's a search, whether the Fourth Amendment is even implicated.
I mean, one of the things that strikes me here is the term probable cause is not itself self-defining, and most of the way we know what probable cause is because we have a body of case law that talks about it, and it talks about it in an investigatory criminal context. And in this context, that way of figuring out whether there's probable cause just disappears, because that's not the context we're in. So I guess I'm wondering whether then taking a term from a context which has a body of precedent that is pretty much irrelevant to this one, that seems like a bad idea. And maybe what we did in City of Brigham and in Fisher is exactly what we should have done, is we just use a different language, and we don't try to grade that relative to probable cause. It's just sort of a different inquiry, but it does focus on what's important. Do you have to have an objectively reasonable basis for believing that somebody needs emergency help? And I guess what I'm saying is maybe in those two cases we did like the best thing possible, and we're not going to be able to do anything better.
So Justice Kagan, the court's always been reluctant to adopt a third standard. I think in Montoya it said...
Well, we did adopt a third standard, or, a third standard. I mean, we used different words for this different context, and why not just leave it at that?
Because, Your Honor, it produced a lot of confusion in the lower courts, as we explained in our cert petition. You had a significant number of circuits and states that applied a lower standard akin to reasonable suspicion, like the Montana Supreme Court did here. You had other states that applied a probable cause standard. And we do think that given that this situation is so recurring and that...
But why not just say this is a different context, our probable cause precedents are pretty much irrelevant and can't help us. We think we got the standard right. That doesn't mean reasonable suspicion. Reasonable suspicion is an entirely different thing. Go figure it out. Case by case in the normal way that courts do.
Well, even the state doesn't defend reasonable suspicion at this point.
I know. And we would say it's not reasonable suspicion. It's just this. Do you have an objectively reasonable basis for believing that emergency help is required?
If the court were to reject a reasonable suspicion standard, we would be entitled to a remand even on that ground. But we do think that it would be better, that the better approach is to provide a little more guidance to officers and first responders. And while probable cause hasn't been applied by all courts, it actually has been applied by a significant number of the lower courts.
I think it's very difficult because we talk about how much information the person has. I think it could be more pertinent in the situation of how little information they have. I mean, think about an officer who walks down the regular beat and there's a picture when there is some person lying on the sofa that looks like he's, kind of an awkward position and keeps going down, and 2 hours later comes back, it's the same thing. Mm-hmm. He knows nothing about it except that the guy appears perhaps to be dead or passed out or something. So he knocks on the door, he knocks on the window and gets no response, and then figures he's worried about it. He breaks the door down or picks the lock and he walks in and the person wakes up and there's 3 kilos of whatever. And I mean, is that is it wrong that he did that out of legitimate concern and he didn't know that that's just Fred or whatever?
We know that
I'm just trying to think. I would want a police officer in a situation who walks by and sees somebody in the community that seems something's wrong. He hasn't moved in 4 hours. It doesn't look like he's taking a nap. But and then what happens? I mean, then does he have sufficient basis to justify the search that led to the illegal drugs? So he doesn't know anything. I mean, maybe if he knew a little more, or maybe his regular habit is to go to the pub at night, and that's why I find it very difficult to articulate a standard. I mean, I don't think it can be based on a probability of something going awry, or because you do want police to be, on the lookout for things that might be dangerous, even if it's not crime or criminal.
Certainly, but the court has always said subjective intent. So you might well be concerned as an officer or a first responder or even an ordinary citizen that something's going wrong inside the house, but there could also be innocuous explanations, even in the scenario that you just sketched out, Mr. Chief Justice. In a lot of the scenarios that Justice Kavanaugh similarly sketched out in his concurrence in Cornelia, it could tack either way, but oftentimes in those scenarios, the report, especially if it's from a neighbor or from a relative, is going to have a lot of information about why it's uncharacteristic, why this is weird, and that is powerful information and can be linked up with corroborating evidence to support going in.
One question, and maybe Montana can answer this, weigh in if you don't know. Would it be normal or best practices to send in just medical personnel when someone has cocked a gun over the phone and is known to be armed?
No, Your Honor. I believe in those circumstances, officers would be called to the scene.
Would it be helpful, do you think, to clarify, I mean, if there's some ambiguity about what the standard was that was applied. So we don't care about that, okay? It's what we said in Brigham City. And then apply that standard to these facts. We don't have to. We could send it back. But would it help to provide guidance to confused lower courts for us to use a concrete set of facts to explain what that means?
Absolutely, Justice Gorsuch. This is a scenario that officers face every day. Emergency aid scenarios are very common, whether it's a suicide call, like in this case, a call of an elderly individual who's missing, or a hybrid scenario like Brigham City or Fisher. Having this court apply whatever the Brigham City standard to the facts in this case would be very helpful.
And we have a full enough record to do that, you think?
Absolutely.
All right. And what do you say to your friend on the other side about the necessity defense being more liberal under the restatement than it was at common law?
I think at common law, my friend on the other side pointed to the cases of Rex v. Cody and Scott v. Wakeham. When you read those cases, it's all based on a reasonableness analysis. In the Rex v. Cody case, the restraining was justified if it had been proved to have been with the best motives or necessity was manifestly proven. To me, that sounds like a reasonableness standard. Now, some of the issue in terms of what the reasonableness standard at the time is that we don't, in tort law, we don't get the full reasonableness standard until 1837 in the Vaughan case in England. But Cook is writing in the 16th century about applying the law of reason to the reasonableness of the common law. And so implicit in jury and judicial verdicts at the time, the concept of the ordinary person and reasonableness is baked into the common law in England and the common law here, and of course textually in the Fourth Amendment.
I actually don't see any them addressing the reasonableness of the manner in which this occurred. And I pointed to things. Justice Barrett was right. You're not going to send medical personnel into a room with an armed person, but you do call medical personnel to make calls or to talk to someone who's suicidal on the phone. It happens quite often.
They could do that. Now,
you could put a megaphone out there.
I will point out the time exigency here is that they did call medical personnel when case after the entry and he had been shot, but the officers here.
Yes, after he had been shot. Right. When they had a great probability of knowing that he was seeking to be suicide by cop.
There's no indication that EMTs would be able to talk down Mr. Case. In fact, Chief Sather, who had known Case for 30 years, testified that based on prior incidents, he actually thought that he could talk Case down and get him out of the house. It was only after they received the reliable indicia that Case had actually suffered a gunshot wound that the chief arrives and says, we have to go in.
Let's check both of those boxes in our hypothetical.
Then yes. And I want to return to Justice Jackson's point because
So yes,
they could regulate.
The state could forbid a regulated licensed professional from affirming homosexuality
if that
were consistent with the then prevailing standard of care.
That's right.
And so likewise, if the prevailing standard of care were to change or to solidify that this sort of talk therapy is beneficial to minors or at least not harmful to minors, then a state could pass a mirror image statute to Colorado's that prohibits any attempt to affirm changes of gender identity or sexual orientation, and that would be subject to mere rational basis review on your theory.
That's right, Your Honor.
It seems to me your statute dictates opposite results in those two situations based on the viewpoint expressed. One viewpoint is the viewpoint that a minor should be able to obtain talk therapy to overcome same-sex attraction if that's what he or she wants, and the other is the viewpoint that the minor should not be able to obtain talk therapy to overcome same-sex attraction, even if that is what he or she wants. Looks like blatant viewpoint discrimination.
As I heard your examples, I think they would both be permissible because it didn't sound like in either case the goal was to actually change sexual orientation. And again, that's the touchstone because that's where the harms come from.
Can I ask you about licensing? You talked a lot about malpractice, but don't states tend to tie licensing requirements to the standard of care? And so if we had a situation like this in which a state licensing board disciplined a doctor for a speech-based practice outside of the standard of care, would that doctor have a First Amendment defense?
So there is a long history and tradition in this country of licensing, and even licensing for people who engage in speech. What there isn't a long history and tradition of is, as a condition of that license, imposing a prior restraint on the types of speech they engage in. And we know from NIFLA that the mere fact that there's a license isn't enough to obviate First Amendment review.
Do you think if there were the exact opposite kind of law, so this is a therapist that, consistent with the child's goals, is trying to get the child to accept a gay identity or a trans identity. So it's exactly the same statute, but it's just flipped around. Same argument?
Strict scrutiny would apply to that unless there was conduct involved. If there was conduct and that conduct was unlawful, then the speech integral to unlawful conduct doctrine would apply. But if it's only speech, then yes.
Right. I'm assuming that your caveat, unless there was conduct involved, applies to your case as well, right? That applies symmetrically to both, unless there was conduct involved that was of that kind.
That's correct.
Okay. So symmetrical.
Correct.
Okay.
So
all of that.
You are right that fits the definition of the law. But we have been very clear in Susan B. Anthony that there has to be a sufficiently eminent and credible threat of prosecution. We've said merely having a law on the books is not enough. A chilling effect doesn't exist. This is an unusual case because we have basically 6 years of no enforcement of this law, 3 before this lawsuit, 3 since. And we have the entity charged with administering the law saying we're not going to apply it to your kind of therapy. So how does that fit into being an eminent threat of prosecution?
Mr. Mupon, you have an evocative example in your brief which I want to pick up on, which is, let's say there's a school of psychotherapists that think that the best way to deal with suicidal patients is to go dare them to commit suicide. And you basically say, yes, strict scrutiny applies, but don't worry, it could be satisfied in a case like that. And I just want you to run through that and tell me why you think strict scrutiny applies and why you're confident that it could come out the way you think.
So I'll say a couple things about that, Your Honor. So first, we think strict scrutiny applies if the law was structured the way this law is.
Yeah, that's what I'm
So
assuming.
if it was a categorical prior restraint. So if it was a categorical prior restraint, we think strict scrutiny applies because it's content-based, it's not incidental to any conduct, and there isn't any history or tradition of imposing that sort of prior restraint. So we think you're in strict scrutiny. As to why we think you could satisfy strict scrutiny, because that type of speech has utterly no redeeming value.
But I guess the argument that the Tenth Circuit seemed to find persuasive was that if you are in the world of medical treatment, you are regulating conduct, that the medical treatment itself is an activity that is being licensed and that is being performed, and that it really isn't speech, that speech is the tool that is being used, just like in other medical treatments. You have scalpels, you have tools that medical professionals use to accomplish certain goals and to provide treatment. And so in that sense, I think their argument was that speech is incidental to the provision of this medical treatment. So I guess we need to understand whether her therapy qualifies as medical treatment.
The question is whether her speech is incidental to conduct. That's what the court said in NIFLA. It said that if there's professional conduct, then speech that's incidental to that could be regulated.
So treatment is not conduct in your view, medical treatment.
If the treatment consists only of speech, then it doesn't trigger the speech incidental to conduct doctrine. And here we're just in First Amendment land where there is full, robust protection.
Is there any reason you can't have a civil proceeding running parallel to the criminal proceeding? The state has an agency to allocate fault in the case of auto accidents, and whoever has to pay, and somebody steals a car and, crashes the car and he's criminally prosecuted for that. And in the same accident, just has to go through a civil process where he may also be assessed a fine. Is there anything wrong with that?
No, I think Congress could have chosen to do something like that. Now, depending on how it was structured, that may raise some serious problems under the Seventh Amendment. But putting the Seventh Amendment consequences of such a scheme aside, Congress might have created such a system, but that's not what it did here.
Could it just say we intend this to be civil and have the operations of the statute operate in the same way, and then we would say it's civil? In other words, it seems odd that so much turns on the label as opposed to the operations of how the statute works.
Well, I think if Congress perhaps just said the word civil but did everything exactly the same, we would still be before you arguing that that is quintessential criminal punishment. But this court has said that the inquiry at the first step of the criminal punishment.
Quintessential why? If it's payment to the victim, just like a tort suit. I know some of the folks have characterized this as just a tort suit like.
Sure. I think if it's still part of the sentence that is imposed by the sentencing court as part of the sentence, together with imprisonment, fines, probation, all of the other criminal punishments, I think our position would still be that is criminal punishment. But Congress could have written a different statute that would have accomplished something civil, again, wrestling with the Seventh Amendment consequences of that. WPA.
And in its legislative history, it didn't seem as though Congress was pretty clear that this was not just about compensating the victims. I mean, I see here a quote that Congress says that the MVRA is, quote, needed to ensure that the loss to crime victims is recognized and that they receive the restitution that they are due. It is also necessary to ensure that the offender realizes the damage caused by the offense and pays the debt owed to the victim as well as society. So it seems as though, at a minimum, Congress was doing more than just saying the victim has to be compensated. And if that's the case, why is it characterized as a criminal statute if there are two motives operating?
Sure. May I answer? So to take those questions in two parts. First, absolutely, Congress made crystal clear in the legislative history that it thought the MVRA was a criminal statute. If you read the Senate Judiciary Committee report, it uses the word criminal more than 40 times, and the only time it uses the word civil is to distinguish restitution from civil proceedings. Now, to take the second part of Your Honor's question, the inquiry that this Court has adopted for when is something criminal punishment just asks whether Congress intended to create criminal punishment and whether it has some other purpose, such as here compensation, such as in the case of imprisonment, protecting the public, doesn't matter because all punishments serve more than one purpose.
Suit like?
Sure. I think if it's still part of the sentence that is imposed by the sentencing court as part of the sentence, together with imprisonment, fines, probation, all of the other criminal punishments, I think our position would still be that is criminal punishment. But Congress could have written a different statute that would have accomplished something civil, again, wrestling with the Seventh Amendment consequences of that. The Seventh Amendment is, I think, important here because it is part of the backdrop against which Congress legislated in the MVRA. In the wake of the VWPA, which was the predecessor to the MVRA, the courts of appeals uniformly rejected Seventh Amendment challenges to restitution on the ground that restitution is criminal punishment. This court commented on that uniform consensus in Kelly versus Robinson before Congress enacted the MVRA. This court also construed the VWPA in Huey before the MVRA and applied lenity to the VWPA as a criminal statute. All of that is part of the backdrop against which Congress enacted the MVRA. And not only did Congress not do anything to signal it was intending to depart from that consensus, but it carried forward the same operative language from Section 3663 in the VWPA.
And in its legislative history, it didn't seem as though Congress was pretty clear that this was not just about compensating the victims. I mean, I see here a quote that Congress says that the MVRA is, quote, needed to ensure that the loss to crime victims is recognized and that they receive the restitution that they are due. It is also necessary to ensure that the offender realizes the damage caused by the offense and pays the debt owed to the victim as well as society. So it seems as though, at a minimum, Congress was doing more than just saying the victim has to be compensated. And if that's the case, why is it characterized as a criminal statute if there are two motives operating?
Sure. May I answer? So to take those questions in two parts. First, absolutely, Congress made crystal clear in the legislative history that it thought the MVRA was a criminal statute. If you read the Senate Judiciary Committee report, it uses the word criminal more than 40 times, and the only time it uses the word civil is to distinguish restitution from civil proceedings. Now, to take the second part of Your Honor's question, the inquiry that this Court has adopted for when is something criminal punishment just asks whether Congress intended to create criminal punishment and whether it has some other purpose, such as here compensation, such as in the case of imprisonment, protecting the public, doesn't matter because all punishments serve more than one purpose.
Thank you.
Thank you. Justice Thomas? Justice Alito?
What will be left of Smith if we rule in your favor? Suppose that a state sex offender law provided that the sentencing judge would determine how long an offender needed to register, or suppose that the state could summarily revoke probation if a defendant failed to maintain his registration. Would that mean that the sex offender law would be penal?
Not necessarily, Your Honor. We don't think there's any inconsistency between a holding in our favor here and Smith. In Smith, the requirement to register as a sex offender was not imposed as part of the sentence. The legislature used the sentencing process simply to notify the offender of the need to register, but it was not imposed as a punishment. There is a distinction between the sentence itself and conditions of release or probation. Those are conditions on the sentence but are not the sentence itself. So we don't think that a condition of release, such as the obligation to register as a sex offender, would necessarily amount to criminal punishment in the same way that conditions of imprisonment, like cell phone restrictions, are not themselves punishment.
Would you say that the primary function of restitution under this statute, the statute you would like us to apply, is penal or civil?
We think
the primary function is the primary function to punish, or is the primary function to provide compensation to make victims whole to the extent possible? Which is primary?
The court in Paroline said the primary purpose is compensation, but we think the penal purpose here is just as important and primary, I would say, as the compensatory purpose.
Justice Sotomayor?
Under the statute, drug offenses order restitution to the society, don't they?
Yes, and we think
so. That's why you're saying it's equal.
Yes, that's a very good indication that Congress was intending to do more than simply compensate individual victims.
Number two, our ex post facto jurisprudence has three components. Was it being applied to previous conduct? The first is the question before us, is it criminal or civil? But that there's a third component, does it increase punishment? On that question, there's a circuit split, and we didn't grant cert on that, correct?
That's correct.
So this, at worst, would be a reverse remand.
Yes, we agree with that, and I think the government does as well.
Okay. Thank you.
Justice Kagan?
What about these provisions that say that, on the one hand, the award is offset by any civil judgment received, and on the other hand, that the victim can keep coming in, however many years later, to offer proof of further damages? That really, both of those seem very odd if the statute is primarily punitive.
Sure. So as to the first one, we think that feature of the scheme supports us as a matter of statutory construction, because those provisions, which are in 3664J and L, distinguish between what happens at sentencing, at the imposition of restitution, and what happens in a subsequent civil proceeding. And the fact that Congress used the word civil proceeding and those particular provisions, we think makes quite clear that it understood that what is happening at sentencing when restitution is imposed is not a civil proceeding. Now, as to the second point, the fact that victims can come back at future points, first, that is cabined by a good cause requirement. There needs to be some reason why that was not presented to the sentencing court at the time of sentencing. But putting that aside, we think that one particular feature of the statute, similar to the narrow opportunity to obtain a civil lien, just doesn't overcome all of the indications that Congress understood it was imposing a sentence.
Mr. Chief Justice, and may it please the Court, Congress implemented restitution under the Mandatory Victims Restitution Act as criminal punishment. The text makes plain, first, that restitution is punishment. In the statute's terms, it is a penalty or sanction. And Justice Alito, to your question, that fact alone distinguishes restitution in this case from the registration requirements at issue in Smith v. Doe, which this Court held wasn't punishment at all. Then the Court has to consider whether this is criminal or civil punishment, and we think the text is equally plain that it is criminal. Restitution is imposed for a criminal offense on a criminal defendant at criminal sentencing where the United States stands as the adversarial party. And if there were any doubt, the statutory history dispels it. The Court of Appeals had uniformly held that restitution under a predecessor statute was criminal punishment, and Congress replicated the relevant language in the MVRA and doubled down on features indicating a punitive intent. This Court should vacate so the Court of Appeals can consider in the first instance the United States' alternative arguments for affirmance. I welcome the Court's questions.
Does it make a difference if this sanction was imposed in a separate proceeding?
Does it make a difference if it had been imposed outside of the sentencing context? Well, I don't think it would change the nature of restitution as punishment, given that Congress refers to it as a penalty, but it might change whether we conceive of it as a civil penalty, like the administrative penalties at issue in Hudson or in Ward, or whether we consider it a criminal punishment. The fact that this penalty is imposed in a criminal proceeding is one strong indication that it is meant to serve as criminal punishment.
Do you think that all sanctions imposed in criminal proceedings are, in fact, penal or criminal?
So I think this is an important distinction, Justice Thomas, and I want to be clear that we do distinguish between what is part of a criminal sentence and what occurs at criminal sentencing, because we agree with amicus that not everything that occurs in criminal sentencing or even that appears in a criminal judgment is necessarily part of the punishment and therefore part of the criminal defendant's sentence.
And I just wanted to ask you analytically, and I'll show my cards and say it's just because of thinking about this Dig argument. Do you think analytically we should be thinking about these as two distinct statutes, or should we be thinking about the VWPA and the MVRA as just different amendments to the same basic statute?
We think that you can think today of both Section 3663 and 3663A as part of the MVRA because restitution imposed under either scheme would be subject to all of the MVRA's many provisions, including its collection authorities, its procedural safeguards, and all of those provisions are relevant to the Court's analysis. But to be direct about the DIG, if the Court wants to identify the provision at issue here, we do think it should take the case on the premise that it's Section 3663A. That was the government's position before the Court of Appeals. The Court of Appeals accepted that premise. Petitioners no longer disputing it or asking this Court to revisit that factual predicate. And so we think it's appropriate for the Court to resolve this case on the same basis that we asked the Eighth Circuit to rule in our favor below.
Then I just wanted to ask you analytically, and I'll show my cards and say it's just because of thinking about this Dig argument. Do you think analytically we should be thinking about these as two distinct statutes, or should we be thinking about the VWPA and the MVRA as just different amendments to the same basic statute?
We think that you can think today of both Section 3663 and 3663A as part of the MVRA because restitution imposed under either scheme would be subject to all of the MVRA's many provisions, including its collection authorities, its procedural safeguards, and all of those provisions are relevant to the Court's analysis. But to be direct about the DIG, if the Court wants to identify the provision at issue here, we do think it should take the case on the premise that it's Section 3663A. That was the government's position before the Court of Appeals. The Court of Appeals accepted that premise. Petitioner is no longer disputing it or asking this court to revisit that factual predicate. And so we think it's appropriate for the court to resolve this case on the same basis that we asked the Eighth Circuit to rule in our favor below.
And that section was not in effect when he committed the crime, correct?
That's correct.
So that's the source of the ex post facto problem. No matter what happened at sentencing, at the time he committed the crime, 3663A was not in effect, and today he's being held to account under that provision.
That's correct, Justice Jackson. I would make one clarification. The MVRA by its terms applied to petitioner. So if the district court didn't apply 3663A, it could have only done so if it determined that that provision was criminal punishment, the very question at issue here. Now, there would be a separate question as to whether the limitations period that the government is currently attempting to apply to petitioner might constitutionally apply. It's our position that it could, even though his restitution obligation was criminal punishment, because we don't think increasing the time to collect restitution increases his punishment.
That's the argument you want to preserve.
But that's the argument we're trying to preserve for remand.
Can I just go back to Justice Alito's colloquy with you? Because I guess I'm still wondering whether your argument flows from the idea that there might be different purposes of punishment and that you could have a punitive measure that is imposed for rehabilitative circumstances, and with an idea that you are making this person pay back society, you're making this person make amends for what it is that he's done, but it really is still a part of the punishment in the way that theorists have traditionally understood various purposes of punishment.
We think that's right, and this court made a similar observation in Callais itself, where it said that restitution serves as a particularly effective rehabilitative penalty precisely because it forces the offender to confront in concrete terms the harms that his actions have caused to a real person, more than a fine, which is paid to an abstract entity like the state would. It also serves a particularly effective deterrent purpose for that reason, by closely aligning the punishment that the defendant faces with the harm that he's caused.
So even if it's victim focused, it can still be punitive in this way.
Yes, absolutely. And we do think that this punishment here serves penological goals as well as compensatory ones.
You stated my question better than I did.
But I don't think that ultimately holds up, because it is the tort system that is a mandatory compensation regime. It is the civil justice system that is a mandatory compensation regime.
There's compensatory in both cases before, just an insufficient one, and Congress made it more punitive, more compensatory.
It really wasn't. It was capped at compensation, but it empowered judges to say, how do I impose an appropriate punishment on this person by calibrating the amount of restitution in connection with all the other things I'm going to impose at sentencing. So it was really more of a criminal system.
Counsel, you began with Allen against Milligan. That case, of course, took the existing precedent as a given and considered Alabama's application of its approach to the evidence and all that under that precedent. Is that your understanding as well?
That's correct. In fact, the case was stayed because this court held that case in abeyance until it decided Milligan, because it understood Milligan to be important to understanding the case in Robinson.
But it was a case in which we were considering Alabama's particular challenge based on its what turned out to be an improper evidentiary showing.
I'm sorry.
In other words, we were looking at Alabama's suggestion that how to apply its body of evidence or which evidentiary considerations we should take into account under the existing precedent.
That's correct.
So we've assumed, without deciding, this is picking up on Justice Gorsuch's questions, that complying with Section 2 is a compelling interest for purposes of the 14th Amendment.
Correct.
And now this is kind of picking up on some of Justice Alito and Justice Thomas's questions earlier. How are we to think about that when we're thinking about the Robinson litigation? Because it was a preliminary injunction, and Louisiana, of course, argued there that no, it wasn't a violation of Section 2 to have those maps. So how do we judge the compelling interest? in avoiding a violation of Section 2, if the state doesn't really think it violates Section 2 and it hasn't been finally adjudicated yet, how do we approach assuming that compliance with Section 2 is a compelling interest, how do we think about that in a context like Robinson?
So states can, for good reason, draw a map that addresses Section 2 prophylactically. Here we have a finding from a district court based on a robust evidentiary record that we were likely to succeed on our Section 2 claim. This is not the first case. There are many cases that have provided the basis for an opportunity map to be drawn just on a preliminary injunction motion. And again, that finding by the lower court was affirmed by 2 federal panels of the Fifth Circuit, and this court had an opportunity to revisit the Robinson litigation and did not.
But what if, district courts sometimes make errors of law, right? So what if the district court, I guess I'm trying to figure out how much weight then the district court's finding has in comprising that compelling interest in avoiding the Section 2 violation. Do you see what I mean? Like, what if the district court was just wrong, and what if the state thinks that the district court was wrong?
Well, the state has already conceded that it.
Okay, no.
The state already conceded that it should comply with the Robinson decision.
Right. It got complicated here because of all of the other litigation, but why don't you just strip out what happened and answer the question, like, at the time Robinson was decided. If Louisiana thought that the Robinson court was wrong, that the district court was wrong, but it wanted to avoid the court-imposed map, wanted the opportunity to draw its own map, Justice Kavanaugh's been asking you what role race can play without running afoul of the Equal Protection Clause. And the state would have to say at that point, well, we're weighting race heavily because we have a compelling interest in avoiding a Section 2 violation. And the state's position might be, we don't actually really think that we violated Section 2, but we have a litigation risk. We know that if we don't draw this other map, the court may impose one. On that understanding, on those facts, not concessions and whatever is made, is that then a legitimate, compelling state interest when there is the possibility and the state, in fact, thinks that the district court was wrong?
It is still a compelling governmental interest. The state can do what it did here, which is to appeal to the Fifth Circuit, and the Fifth Circuit considered the same evidence and unanimously found that the Robinson court was correct. Yet another Fifth Circuit panel also affirmed that decision.
General, the race-based redistricting that you're now objecting to is redistricting designed to remedy a specific, identified, proved violation of law. More, a specific, identified, proved racial discrimination by the state. That's the way in which the race-based districting is coming in. It's coming in as a remedy for specific, proved discrimination on the state's part. How could that possibly fall subject to the categorical rule that you're suggesting?
Your Honor, I respectfully but firmly resist the premise that this comes to the court on a finding of specific discrimination by the state. I think if anything is clear about how Jingles plays out on the ground, it is that once you run the 3 preconditions and get to the totality of the circumstances, it's anyone's guess what the alleged violation is. I think Justice Thomas's colleague—
General, what Jingles does, and, the idea that this is like 50 years later, this is not a kind of Shelby County thing, where one could say that Congress had acted and 50 years later, the conditions on the ground might have changed and there would be no way to respond to that change. Because what Jingles does and what these Section 2 suits do is they ask about current conditions, and they ask whether those current conditions show vote dilution, which is violative of Section 2. So they say, is there racial segregation, racial residential segregation now? Is there racially polarized voting now? And when the state fails with respect to those issues, when those conditions obtain now, what our precedents say and what you're asking us now to change What our precedents say is that when those things operate currently, right as of now, and are proved in a courtroom, that that still there can't be a race-based remedy.
That's correct, Justice Kagan, and I think the two trends that my friends on the other side point to, the rates of residential segregation and the rates of racially polarized voting, are what allow them to get past the Jingles preconditions. They told you at page 33 of their yellow brief that those things are worse today in Louisiana than they were in the 1980s, and this court said at page 228 in Northwest Austin that those sorts of factors are not evidence of intentional discrimination. That's not intentional discrimination.
Can I clear up a couple of factual points that have been brought out by the questioning? Your HB1, enacted in 2022, followed to a large extent the map that you had for the prior decade. Isn't that right?
That's exactly right, Justice.
It was suggested that that prior map was discriminatory. What was the origin of that prior map? Do I remember correctly that it was pre-cleared by the Justice Department?
Twice. That's correct, Justice Alito.
So it wasn't – there's no finding that that map was based on discrimination and that by following that map you were perpetuating prior discrimination.
No, Justice Alito, and I think that's why I firmly have to resist any suggestion that the Louisiana state legislature is out here targeting minority voters and trying to abridge their right to vote. That is just completely unfounded.
Can I clear up a couple of factual points that have been brought out by the questioning? Your HB1, enacted in 2022, followed to a large extent the map that you had for the prior decade. Isn't that right?
That's exactly right, Justice.
It was suggested that that prior map was discriminatory. What was the origin of that prior map? Do I remember correctly that it was pre-cleared by the Justice Department?
Twice. That's correct, Justice Alito.
So it wasn't – there's no finding that that map was based on discrimination and that by following that map you were perpetuating prior discrimination.
No, Justice Alito, and I think that's why I firmly have to resist any suggestion that the Louisiana state legislature is out here targeting minority voters and trying to abridge their right to vote. That is just completely unfounded.
As to the suggestion that there was a proven violation in the Robinson litigation, that was a preliminary injunction, right?
That's correct, Justice Alito.
So there wasn't a finding that there was a violation, at most a finding that there was likely to be a violation shown. And is it not correct, for the reasons that I brought out in my questioning of Ms. Nelson, that what the district court did there was not to ask whether the minority group was sufficiently compact, but whether the district itself was sufficiently compact?
That's exactly right, Justice Alito. And if you look at the black population in Louisiana, I mean, it is all over the place. You can identify pockets of black voters, but they are dispersed across the state. There's no way you can conceive of that population as compact.
Thank you.
Justice Sotomayor?
I may be remembering the record wrong on this because it was a while back, but if I recall, the district court looked at the three main parishes that make up District 6 now and looked at it and said they have a commonality of history. Many of its residents go from where they live near the Baton Rouge area to work or go to school, and they go back to their communities. They have long family ties between the communities and among the communities. There may be a difference in education and some income differences, but that's true of all the districts in Louisiana. You've got the districts that are protecting incumbents, where in the north there's less money than in other areas. So those differences are not meaningful. But I thought the district court did a very careful analysis of the commonality of interest of that black community. You may disagree with its finding, but it did do that analysis.
Your Honor, no doubt the Middle District purported to run through the Jingles analysis, and it said, it will be the
unusual. You're disagreeing with it, but it did do that.
It did what this Court's precedents allow lower courts to do. And, Justice Sotomayor, my only point in response to that is to say when the district court was asking about what the minority group does and thinks and prefers, it is exactly the sort of racial stereotyping that this Court's precedents say is impermissible.
Counsel, with respect, the last time the SG was here before us on behalf of your state, they said that race did not predominate just with your creation of District 6, Because what you were trying to do and why it's oddly shaped was to protect incumbents. Are you walking that back?
Your Honor, our position in our supplemental briefing on racial predominance is as follows. If race is a non-negotiable in the drawing of a new district, we think that should satisfy this Court's predominance analysis. And the argument you
but that's just it, which is, was it? What really was non-negotiable for you was nonpartisanship. And you could have picked one of the other maps, the illustrative map. You didn't have to, but you drew this because of your partisan needs more than because of race.
We drew it for partisan reasons, Justice Sotomayor. My point and the point we make at the end of our opening supplemental brief is to say when this Court's racial predominance questions ask about non-negotiability, it shouldn't matter if race is the one non-negotiable factor or it's one of 10 non-negotiable factors.
I think the reason they say we haven't really addressed their proposal before in our jurisprudence, in part because before Rucho, states wouldn't articulate that objective explicitly, and therefore it's an open question. Do you agree with that?
I think as a practical matter, that's probably true, Your Honor. I mean, I think pre-Rucho, states were going to be very hesitant to venture out to say, overtly, like politically, like here's what we're doing. And so that is, I think, a great explanation of why the Court's cases have treated the political versus racial divide as it does.
And just on common ground here, because I think it's always important in a case like this where there's disputes to identify what's common ground. Justice Jackson said the goal is equal opportunity for all Americans. I think we all agree on that completely. I think the reason they say we haven't really addressed their proposal before in our jurisprudence, in part because before Rucho, states wouldn't articulate that objective explicitly, and therefore it's an open question. Do you agree with that?
I think as a practical matter, that's probably true, Your Honor. I mean, I think pre-Rucho, states were going to be very hesitant to venture out to say, overtly, like politically, like here's what we're doing. And so that is, I think, a great explanation of why the Court's cases have treated the political versus racial divide as it does.
And just on common ground here, because I think it's always important in a case like this where there's disputes to identify what's common ground. Justice Jackson said the goal is equal opportunity for all Americans. I think we all agree on that completely. And the goal, of course, is racial non-discrimination. But at the same time, given history and given Congress's action, the goal is making sure that there have been sufficient remedies for the history of discrimination in the United States, and we've seen that in the school desegregation context, in the college admissions context, and a variety of contexts. And then Ms. Nelson, I think, suggested if there is going to be a temporal limit, she doesn't want one at all, but then I think she said if there's going to be one, it should be identified in advance. And I just want to get your response to that.
Our response to that is simple, Your Honor. Over 3 decades, dating back to Shaw 1 and Miller, the Court has always qualified its voting cases with the caveat that racial stereotyping is bad, the 14th Amendment forbids it, and in all events, it can't persist. I think anybody remotely involved in redistricting knows those caveats and has been on notice since the 1990s. And so, as recently as this Court's plurality opinion in Schuette and then SFFA, where the Court again reproduced that black-letter law that racial stereotyping is not permitted under the 14th Amendment, the warning bells have been sounding for decades, and I think that's a long enough notice for anybody involved, Your Honor.
In response to Justice Kagan, Ms. Nelson said that black representatives and justices in Louisiana have primarily, if not exclusively, been elected in minority opportunity districts, and that the results would be terrible. You want to respond to that?
Sure, Your Honor. I mean, I think there's been a lot of sky is falling rhetoric from the other side in this case. And I just want to give you one political reality why I think that's a little overstated, which is remember that in a case, use a state like Louisiana, Republican legislature, If a Republican legislature wants to maximize its political seats, draw a 6-0 map, remember what has to happen with the hundreds of thousands of Democrat voters that currently exist in the majority Democrat districts, District 2 and District 6. They have to go somewhere, and that means that if the legislature wants to take the risk of maximizing, what they're doing is turning safe districts for high-profile political incumbents purple. And that, I think, is a very dangerous political risk. I don't know what our legislature would do if the court rules in our favor, but I'm just saying that's one political reality that makes me pause and say, I don't think the sky is going to fall.
Thank you.
Justice Barrett?
Just have a clarifying question to see how I'm thinking about this or the arguments that are being made. Would you say that Section 2, insofar as it goes beyond just intentional discrimination, because as Justice Kagan said, Congress amended it when we said that before, is itself an exercise of the enforcement power? Judge, I'm going to assume here that Congress's enforcement power is necessary and the congruence and proportionality test applies to Section 2. Do you agree with that conception? And I guess just to tell you where I'm coming from, I mean, it's one thing to say that the map itself is the remedy, but it might also be that the statute itself, insofar it goes beyond intentional discrimination, is the remedy. Is that a way to think about it, or is that how the arguments are going?
I think that's right, Justice Barrett. I mean, I think the court's precedents assume that if a plaintiff in a Section 2 case can prove up the preconditions and the totality of the circumstances, the automatic remedy, at least in this case, is going to be a majority-minority district. And I think the court's precedents assume that that is statutorily mandated. Like, that's just the natural the consequence of a violation finding. So I do think it's built into the statute. Now, there was a lot of discussion earlier about whether we're attacking Section 2 itself, like facially, and that's just not true. The re-argument QP in our briefing has been focused solely on this use of race-based redistricting as a remedy. I think all the other applications of Section 2 that this Court has considered remain fair game. If a plaintiff especially can show intentional discrimination, of course, that all remains fair game. But I think we're narrowly focused here on the use of race to draw district lines insofar as the Court has understood that to be mandated by Section 2 to remedy an alleged violation.
So you don't understand yourself to be arguing that any part of Section 2 is itself unconstitutional, but simply as the way that courts have been applying it goes beyond.
That's correct, Justice Barrett. I mean, this Court's precedents culminating in SFFA have said if the racial classification that a government's employing to allegedly remedy a violation is what's at issue, like, that's the constitutional problem, and that's where we focused our briefing.
So if I'm right that Section 2 is about identifying the problem and then requiring some remedy, I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority
it's
black
not,
district.
because that, again, just trust me on this, the second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the Court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you. Go away. In this case, the Court said, I see. I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
Right. And the problem, Justice Jackson, that the Middle District identified was not intentional discrimination. And in fact, I think
Why
when
do
I
you
hear
need intentional discrimination to remedy a problem like the one that I've identified?
Because if you're going to use race the way that the Robinson appellants want the Court to use race in drawing a second majority minority district, you've got to have a compelling interest.
And what I understood the trial court here to be doing was just eliminating that very narrow category of conduct that a lawyer engages in to actually prepare his witness with respect to particular questions and answers on
and that's the line the Court of Criminal Appeals tried to draw. right, between discussion of what you're calling prepping the testimony and discussion of testimony in other contexts.
And why are they wrong about that?
Because that line just, I mean, to even call it a line is wrong. It's not a line. It's a Rorschach plot.
But that's the line that Perry drew. I mean, if you go up a few sentences from the sentence that you read, the court says, an overnight recess is different. Why is it different? Because an overnight recess will go to matters that go beyond the content of the defendant's own testimony, matters that the defendant does have a constitutional right to discuss with his lawyer, suggesting that as to only the defendant's own testimony, the defendant does not have a constitutional right to discuss with his lawyer. Now, then it talks about how, of course, when you talk about the protected matters, there might be some incidental discussion of the testimony itself. So it concedes that perfectly willingly. But it draws a pretty sharp line between matters going to trial strategy and matters going to trial testimony of the defendant itself, and says that that's the reason why the recess, the overnight recess versus 15-minute recess makes a difference.
And like I said, that's no line at all. And the way you can...
But that's Perry's line. I mean,
but no, I don't...
It might be that Perry was wrong, but that's Perry's line.
No, I disagree. Perry goes on to say that a defendant has an unrestricted right of access to his lawyer during an overnight recess, including for consideration of the defendant's testimony. So let me get, so it's, you're trying to draw the same line that the Court of Criminal Appeals drew.
Yeah, I'm not trying to draw it. I'm suggesting that Perry says it right here on page 284. That's the key language from Perry. Now, Perry goes on to say, as I think your friend in Texas goes on to say, that there can be all kinds of places where the testimony has to be talked about as incidental to what is protected, which is the discussion of trial strategy, but not in and of itself.
Okay. First of all, I disagree respectfully with your view of what Perry held. But if Perry held that, I think it's just incorrect, right? So let's work through some examples. During the overnight recess, defense counsel needs to say to the defendant, "Look, you nearly mentioned this evidence. Look, when we resume again tomorrow, you better remember not to mention that because we're going to be in big trouble if you mention that tomorrow." Okay, is that consideration or is that discussion? Is that direct or indirect?
I think maybe I'm missing something, but I would think that would be permissible because it doesn't refer to the testimony itself. It can simply be a reminder, hey, don't go here. That might implicate.
No, but it does refer.
If I might finish.
Oh, sorry.
I think what my colleagues are getting at, and what I kind of thought you even conceded in your brief, is that coaching, and maybe we were defining coaching differently, perhaps that's it, but that there are some things that a district court can constitutionally prohibit counsel from doing while a witness is on the stand, even if there's a recess. You agree with that, right? You think there are some things that can be prevented?
Absolutely. Coaching, I mean, in the sense of suborning perjury, altering the substance of the witness.
Well, I'm not talking about suborning perjury. I'm talking about coaching.
Well, but
right,
we
know. If you don't like that word, let's use management, okay? Which is the word Texas uses.
I like that word even less.
Okay. Yeah. What in the Constitution, what in history suggests that you have a right to manage a witness's testimony during a break?
Okay.
As opposed to derivative or collateral matters that you do need to advise them on. There's a plea agreement, and the way things gone today, maybe we ought to take that plea. There's some excluded evidence. Be careful not to step into that. I can see all of those kinds of comments, but I'm having a hard time understanding historically, traditionally, what have you got that says that there's a right of a witness to be coached, or if you don't like that word, managed by his attorney while he's not on the stand.
Okay.
Whatever the length of the case.
Yeah. So let's talk about the history. So the precise question presented in this case could not have arisen at the founding because defendants weren't allowed to testify until the late 19th
Obviously.
century. Right. And so the question is, what's the appropriate inference to be drawn from historical practice?
And in historical practice is that once you become a witness, you are generally subject to the rule that you can't talk about your testimony. And that's generally understood to mean coaching and managing, but not advice about other legal matters. That's my understanding of the
Can the prosecutor on cross-examination say, well, you said this yesterday, now you say this today. Did you talk to your lawyer last night? Yes. How long did you talk to your lawyer? Did you talk about this? Can he ask whether they talked about that issue?
Well,
is that a violation of the attorney-client privilege?
I don't think so. I don't think so because as the court's held several times, the proper way to ferret out any impermissible coaching is cross-examination, and then the prosecutor arguing to the jury, look, this witness is not credible because this witness was told what to say.
I mean, that's very interesting because I thought the core of the attorney-client privilege had to do with communications between the attorney and the client about important matters. But you think that the prosecutor can go into that?
Well, I mean, honestly, I'm honestly not sure. And maybe you're right. I honestly don't.
Well, it matters a lot because you're saying cross-examination is the corrective.
Let's say the defendant and the lawyer go into their, wherever for the evening recess, and the defendant says something like, counsel, you remember when we were preparing for this, we both agreed we should try to get the jury to focus on Fred. And whenever it's reasonable, I should mention Fred. And I've been doing that. And I notice every time I do that, juror number 8 gets a big frown and shakes his head. He doesn't look to me like he likes the idea of talking about Fred at all. So I think that's a bad idea. Now, talking about Fred was your idea. Do you still think it's a good idea? Can the lawyer respond to that question?
No. They would have to tell them I'm under a court order not to answer
So at that point, he tells the defendant who's facing a capital sentence, I'm not going to tell you. It's a very simple thing. Don't talk about – he's not saying particular things, but let's stop talking about Fred whenever we can.
Yes, that would be managing his testimony. That would be coaching and strategizing with him.
Let's say the defendant and the lawyer go into their, wherever for the evening recess, and the defendant says something like, counsel, you remember when we were preparing for this, we both agreed we should try to get the jury to focus on Fred. And whenever it's reasonable, I should mention Fred. And I've been doing that. And I notice every time I do that, juror number 8 gets a big frown and shakes his head. He doesn't look to me like he likes the idea of talking about Fred at all. So I think that's a bad idea. Now, talking about Fred was your idea. Do you still think it's a good idea? Can the lawyer respond to that question?
No. They would have to tell them I'm under a court order not to answer
So at that point, he tells the defendant who's facing a capital sentence, I'm not going to tell you. It's a very simple thing. Don't talk about – he's not saying particular things, but let's stop talking about Fred whenever we can.
Yes, that would be managing his testimony. That would be coaching and strategizing with him.
Counsel, do you think that the
no, go ahead.
Do you think that counsel can say, listen, I've been noticing that you've been mumbling, and you're also not making eye contact with the questioner, and it would just be a good idea if you stopped mumbling and made eye contact. Can the lawyer do that in an overnight recess?
No, I would consider that to be coaching their testimony. As far as how you present yourself to the jury, I would say that's also the same as the substance of what you're saying.
Don't you think lawyers are going to have very different answers to that questions when they ask themselves that question? Yeah, I guess the point being, is that line really able to be applied in a neutral and equal manner?
They might have some differences of opinion, but we do trust lawyers to use their judgment whenever they are complying with any kind of court order. And our rule also allows any lawyer, if they're just not sure and they really don't want to run afoul of the court's order, to come back and ask the trial court and to say, Your Honor, I wasn't sure about this. Can I get some clarification or even maybe some reconsideration? And let's say it's like 5 in the morning or something like that, and they don't want to bother the trial court judge at 5 in the morning. They can wait till the morning, and they can explain the problem that they were having, and then they can ask for a continuance.
So that's important. That's your solution to ambiguity for the lawyers is just come back and ask if there's something you want to talk about.
That's it for today's High Court Report episode. I hope you enjoyed. If you liked the content, please Follow, rate, subscribe, and share. Talk to you soon.